Thank you very much, and good morning, everyone. Um, Today, I just, in the time available, just wanted to give a brief overview of the main issues that we are asked about in relation to the COVID-19 outbreak. Um, those are primarily to do with, obviously, employee costs, employee relationships, and the management of employees, and relate mostly to unpaid leave, working from home, the collection and handling of personal data, and the taking of precautions by employers in relation to safeguarding measures in terms of obligations and duties. Now, I just start by saying that what I'm going to talk about is not best practice. There's obviously a different issue of best practices, things that are advisable, things that are possible, and things that employers can do that are over and above their legal obligation. I'm going to talk about the legal framework and the legal obligations and rights of employers in relation to those issues. So don't take this as a best practice guide. This is really about bottom line legal obligation. So just talking about those main areas, let me start with maybe the number one issue we are asked about, which is the question of unpaid leave and whether employers can require their employees to take unpaid leave, to give them unpaid leave, or to use the terminology some people have perhaps confused, can they lay off employees for a short period of time and suspend their employment? The short answer to that is that unless there is a very specific and very unusual express right in the employment contract in black and white, the general position is that the employer does not have a right to insist upon and impose unpaid leave. The employer must honor the contract, which obviously involves paying employees. They can, however, request unpaid leave, and that is something which is very commonly being done at the moment by many employers, especially ones in the hard-hit hotel and food and beverage industries at the moment, along with many others as well. Trying to insist on unpaid leave, not only will that not work legally, as the employer does not have a right to stop payment in return for asking the employee to take leave. If the employer tries to insist on the employee taking unpaid leave, not only will that not work, but the mere fact that they have tried to impose something which would be a breach of contract may in itself give the employees the right to claim constructive dismissal. Constructive dismissal is the right for the employee to treat themselves as if their employment had been terminated by the employer. The consequence of that is that rights to redundancy payments, whether those are contractual or statutory under the employment ordinance, which only apply where the employer is the terminating party, those will apply, even though it is the employee's choice to end the employment, because they do it after the employer has attempted to break the contract. They are allowed to treat themselves as having been terminated. So employers need to be very careful. They need to make it very clear that any request for members of staff to take unpaid leave is exactly that. It is a request. It is a question seeking their cooperation to save costs on a short-term basis. For that reason, the request is advisably put in writing, so there cannot be any dispute as to what has been said. And the terms of that request are should be set out clearly, including what will happen to other benefits during that period, whether that be medical insurance cover, other contractual benefits, housing, etc., or is it merely a request that the salary element be suspended? And also, how long will that run for? Will it run for an indefinite period until some future event, such as no more cases in Hong Kong for a 2-week period, or to a specific date after which both parties can review the position, but unless something else is agreed, the obligation to pay salary will recommence and the employee's unpaid leave will cease. So those things need to be very clear and things have to be done by agreement. Pausing there, under Hong Kong law, as a matter of the general legal position, which can obviously be varied by the specifics of people's employment contracts, as a general position, there is very, very limited employee protection against termination in Hong Kong. There is no protection against unfair dismissal. There is no statutory or legal requirement for there to be a particular reason or grounds for dismissal or for any particular procedure to follow. Therefore, as a cost-saving measure, it is relatively straightforward in Hong Kong compared to other jurisdictions to terminate employment. Part of the consequence of that is that it is tempting for employers to say, please take unpaid leave or else we will terminate your employment. Again, making that direct threat of those specific consequences would normally be seen by the courts as an act of constructive dismissal. So that should be avoided. Now, if one group of employees cooperates and takes unpaid leave by agreement and another group refuse, then at that point you can, if you wish, terminate employment of those who were less cooperative. But what should be avoided is making the direct link and threat of dismissal as a means of securing that agreement. Otherwise, employees are able to treat themselves as dismissed, and that may include many who you do not want to lose, and it's not your choice, and therefore those issues should be handled very, very carefully. The second issue we're often asked about is the question of working from home. Firstly, do employees have the right to insist that they work from home because of their perception of the relevant risk levels? The short answer to that is no. Unless their home is one of their contractual places of work, which is very unusual and very rare, then there is no right for the employee to work from home. If they say that they are doing so, the employer is within their rights to insist that they return to their place of work. And if they are not attending at work, then either their benefits will be suspended or other disciplinary action taken against them because they are not fulfilling their employment duties. If a warning and a final warning are given, then that can even include summary dismissal. So the employee does not have the right to work from home and can be instructed under threat of summary dismissal to fulfill their employment duties by turning up. The flip side of that is, do employers have the right to require employees to work from home? The short answer to that is probably. most employees have an implied contractual right to do their job and to exercise their skills and knowledge in order to further their abilities. That's part of the deal under the employment contract. But that is an implied contractual right. So that is based on the presumed intention of the parties. So where you have a very unusual circumstance, such as COVID-19, and where the employer is taking those steps as part of its duty of care to employees, and part of its duty of care not only to that individual employee, but to all of the other employees, it is generally thought by most lawyers that that implied right to attend work, do the job in an unfettered way, an unrestricted way, would be abrogated and would not apply in circumstances where there is a public health need and where there is a specific obligation on employers to take reasonable steps, such as working from home, in order to safeguard their employees as a group. Subject to that issue, asking people to stay away from the office and to work from home is a lawful and reasonable instruction, and therefore employees should comply with that and comply with other ancillary instructions in terms of registering with websites, how to log on from home, availability, etc., use of communications. So as part of that, employees have a general duty to follow the lawful and reasonable instructions of their employer, and therefore not just go home, but also do the things necessary to work properly and efficiently from home. The third area I wanted to touch upon was the collection of personal data. Obviously, that is a far more highly regulated area globally now compared to 20 years ago. You have the GDPR in Europe, and in Hong Kong there is the Personal Data Privacy Ordinance. Now, that imposes actually fairly broad and general obligations on those who collect and store personal data, and they are in fairly broad and reasonable terms. Therefore, in the absence of a specific enforcement notice from the Privacy Commissioner, employers can take a broad, reasonable and sensible approach to their obligations under the ordinance and as regards personal data. Now, one of the data protection principles is to explain to people why their data is being collected and the purpose to which it will be put. So requests for, and the main question that gets raised with us is about taking temperatures on arrival at work, collecting that medical personal data of someone's temperature. Is that permitted? Again, as a general rule, as part of the safeguarding obligation of employers, insisting and requiring their staff to have their temperature taken is a lawful and reasonable instruction. By implementing that, you are collecting personal data, so it must be expressed what purpose that will be used for, namely the monitoring of health for high temperatures, fever as a sign of COVID-19 risk. And as long as that is explained, then there should be no issue of compliance with the data protection principles. One of the other data protection principles is that personal data should not be retained for longer than it needs to be in order to fulfill the stated purpose. which is why we advise when you receive CVs from individuals and seek applications, then if you say you'll keep those on file, you must destroy that information after a reasonable time. You should not keep it forever. The same principle applies to medical information and data gathered from employees. So again, at most, I think you keep records of temperature taken for a few days a week. If someone is okay that day, and looking back a few days, there's no pattern of rising temperatures, then there's no need to keep that data for the purpose for which it was collected. So to comply with that obligation, don't keep that data on file. Don't store everyone's temperature for the whole period of this outbreak for years and years. Use it, make sure people are okay, but then delete that. The fourth area I just wanted to touch upon was the element of employer precautions. As I've mentioned, employers are under a duty of care towards their employees. That includes a duty under the Occupational Safety and Health Ordinance, the Factories and Industrial Undertakings Ordinance, and as a matter of the common law arising from the contractual relationship between employer and employee. So there is a duty to provide a safe system of work. There is a duty to provide a reasonably safe place for work. Now that duty is to take reasonably practicable steps. So it is not an absolute duty to make sure you have done absolutely everything that is humanly possible to do. It is an obligation to take reasonable steps to provide a reasonably safe place for work. Now, what does that mean in practical terms? The short answer is it depends upon the risk profile of your employees, their traveling, the business involved, all of those things. I think you're all aware, and Anamika touched on this previously, of all the many things that can be done. Restricting business travel, obviously any suggestion or risk of anyone actually suffering COVID-19 or having encountered individuals, placing them on a quarantine from their place of work, even if they're not quarantined by the government for having returned from Wuhan, for example. Restricting business travel generally, sanitizing all frequently and publicly touched areas within the office during the day. Something we're asked about frequently is, can the employers require employees to wear face masks within the office? And again, as I've said before, the short answer to that is, I think yes, because it is a lawful and reasonable instruction which has a genuine justification and need for that. Namely, it is the flip side of the employer's duty of care to not only that individual employee, but to all of its other employees as well. So taking all those steps, whether it be masks, sanitation, temperature checks, all of those things, if reasonable steps are taken, the employer will be seen as fulfilling its duty of care. One specific area I wanted to touch upon as regards precautions was the staggering of working hours in order to allow employees to travel to work when public transport is less busy. Now, again, generally that should be done by agreement unless the contract of employment contains a clear and express right for the employer to vary and change the working hours of the individual employee. even if you are allowed to change the working hours under the contract, generally that would only permit a change in specific start and finish times, not to extend the overall period of work. So don't change a 9 till 6 p.m. Period to 8 a.m. to 7 p.m. As an attempt to help take precautions on public transport. Communicate with employees, vary working hours if you have the right to, if not, seek agreement. And again, that's something else that can be done. But in our experience, that's something that employees are very in favor of and are keen to do, and therefore seeking agreement, putting that in writing so there's no confusion about the terms and the hours and the period that that will apply for is all clear and disputable. So those are the four main areas that rise with us. If there are specific questions people have, I could talk about sick leave and sick leave pay for another half an hour. That's quite a complex area. Obviously, if anyone is given a medical certificate that they are unfit for work, there are statutory rights to sick leave pay and protection against termination. If someone has had a disease resembling COVID-19, or indeed even if they've had COVID-19 and have been signed off as completely fit and recovered, then there is obviously protection against disability discrimination. If someone does not have an illness anymore, if someone is able to do their job, then you cannot unlawfully discriminate against them and treat them less favorably just because they used to have a particular illness or condition, no matter what level of heightened paranoia or suspicion there may be. If they are recovered, then they cannot be singled out and discriminated against because of that, because of the disability discrimination ordinance. Those are some of the other areas. There's obviously lots of other aspects of this and lots of very specific legal issues that come up from time to time. I'm sure that if you have any questions on areas I've not touched upon, we can obviously deal with those in the Q&A, but subject to that, Muriel, I think that ends my overview for the moment, so I'll pass the floor back to you. Thank you very much.